Hello everyone and welcome to today's Safety Institute of Australia webinar. Today's topic is titled Chain of Responsibility, Demystifying the Recent Changes to National Heavy Vehicle Law. We are pleased to welcome our presenter for today, Sue Bottrell. This webinar is live and interactive. You are encouraged to post questions to the presenters throughout the presentation. If you're experiencing any technical issues during the webinar, please dial our support number on 1-800-733-416. This number is also listed in the chat box. I'd like to now pass you over to Sue to begin.
Hi everybody, welcome to the webinar. I always get so nervous just before these things, but that's okay. Look, some of you may be familiar with me, some of you might be new to my version of the world. Basically, my background has been in health and safety for the last 20 years. I'm also a qualified lawyer, and I have basically spent the last 7 to 8 years looking at the issue of contractor management and the understanding the obligations owed as between contractors and those that engage them. And really, over 7 years, looking at one case in particular, which is Bottrell Poultry, which is now very, very relevant to the heavy vehicle national law. And also I spent 7 years developing a questionnaire to assist people when they engage contractors, that includes contractors in the transport area, to make sure that they are able to really efficiently ask exactly what it is that we want to know, understand the various obligations of the person engaging the contractor as well as the contractor providing services. So I probably need to get a life, because that's all I've really focused on over the last 7 years, looking at one particular case and developing this questionnaire. It's a really interesting area, and it's an area that is somewhat misunderstood. Workplace health and safety has gone through a lot of pain looking at the issue around contractor management, and due to the changes under the heavy vehicle national legislation and the particularly COR, the same pain is starting to be, I can see, being felt across the transport industry. And so I'll go into the presentation. Please, I understand, just post questions. You can type in questions to me. I'll read those questions out and provide answers to them somewhat along the way, but possibly at the end as well. Please take down my details. I'm always encouraging people to get in touch with me either on LinkedIn or directly phone, email or whatever to clarify any questions that they have. So you'll see on the first slide there, chain of responsibility changes, best thing ever. I know I've been watching, interestingly enough, the rollout of the chain of responsibility. Let's see if I can just move that slide. Yep. And as there was under Y2K and harmonisation of legislation and all other changes that tend to go on in the health and safety world or just the world in general, changes generally come with a message of fear and results in a hell of a lot of confusion. And that is really very much what appears to be happening to me in this space. It makes me quite sad because we've been going through the same thing in health and safety outside of transport for the last sort of 8 years and seem to be emerging from it. So hopefully the transport industry doesn't have to go through the same kind of confusion and fear that went on within workplace health and safety. And look, I twiddle around on the web and I see the kinds of messages that are being sent out about these changes, and these are just some of the ones that I've come across. COR responsibilities, chain of responsibility, cannot be contracted out to a third party. That is a very blanket statement. It is a complex issue and it is oversimplifying things to make a statement like that without qualification, because we'll talk about the whole contracting out. Employers are certainly entitled to buy-in expertise by using contractors, which is a different thing to contracting out, and people just look at these kinds of things in a very basic way and don't understand the subtlety underneath. Your future in supply chain depends on your ability to ensure that any possible risk is removed from causing danger or harm to anyone else, whether they work for your business or not. We'll talk about the implications of reasonable practicability, which puts a limit on or qualifies for duties to ensure the health and safety of both your own employees and others impacted by your business, like other parties in the chain of responsibility. and whether they work for your business or not. Obviously that alludes to contractors, but again, a very simplistic statement, quite fear-driven and quite frankly not accurate. Under the HVNL, parties are also required to take all reasonable steps. That is no longer the test around whether or not you've complied with your obligations, and that was on a very well-known website in relation to COR advice only yesterday, so that needs updating. A manufacturer can be held responsible for the compliance of any truck operating within its supply chain, whether operated by the manufacturer internally or by an outsourced provider engaged within that supply chain. Again, extremely simplistic, quite frankly, on the face of it, incorrect. So we need to understand this better so that we can all get out of a place of fear and get into a place of focusing on what it is that we really need to be doing and making everybody's life a whole lot better. Because quite frankly, this legislation is a really positive move. It clarifies the duties around, people who are involved in the chain of responsibility. It helps people focus on what they have control over and not waste their time trying to take control over things that it's really not appropriate for them to. So in a nutshell, what's happening is the heavy vehicle national legislation is now aligned with workplace health and safety legislation. And I must admit, I've sort of floated the question of I'm not quite sure why heavy vehicle the national legislation is not just part of the workplace health and safety legislation and ultimately a regulation underneath it, rather than creating a whole separate legislative regime. But that's out of my remit. So anyway, so under the workplace health and safety duties, an employer, including employees in the transport industry, should identify all circumstances in which his or her employees could be at risk. So basically that is the essential basic obligation of all employers across all businesses in Australia to manage risks that can harm their own employees, and all the circumstances in which anyone else could be at risk as a result of anything done in his business. So that includes your contractors. So if you're engaging a contractor and you can harm that contractor by things you do in your business, then you've got an obligation to prevent those risks. So the thing is to focus on what do I do in my business. So we'll talk about the fact that, if somebody's distributing goods in their business, they load, they unload, they schedule, they do all of those things. What they don't necessarily do in the business is run trucks, maintain trucks, all that kind of stuff. And that's where we need to really separate out who am I, what do I do, and what do I have control over. And similarly, we'll see the HVNL duty is each party in the chain, and this is the new modification to COR. Each party in the chain is responsible, in the chain of responsibility, i.e. involved in transport activities, for a heavy vehicle must ensure so far as is reasonably practicable, that is the new test, not the reasonable steps, the safety of the parties' transport activities relating to the vehicle. Now, I've got a couple of bits of feedback. The sound is very muffly or too close to the speaker. I've got my headset on, so hopefully it should be okay. But anyway, we'll see how we go. Maybe Shona, if you can look into that. And someone is asking, where is the audio? I can't hear anything. It says, someone's just said it's okay now. Okay, so again, if we go back to the safety of the parties' transport activities relating to the vehicle. So again, focus on what your activities are that are in relation to the vehicle. So again, you're a distributor of goods, you load, you pack, you're a receiver of goods, you unload, all that kind of stuff. You actually don't have necessarily any activities involved in the actual running of the truck, so maintenance, all that kind of stuff. So the two duties are now aligned. The workplace health and safety legislation takes precedent over the HVNL. So where there's a conflict between the two legislations, the duties under workplace health and safety will prevail. Yes, a copy of the presentation is available at the end. Everyone who's participated will receive a link. And also, if you know anybody who wanted to be involved but couldn't, they can also register at a later date and receive a copy of a link. Okay, so Chapter 126C, the safety duties. Well, basically this is the COR overview. Targeted everyone involved in heavy vehicle transport, but only to the extent that they have control or real influence. The thing that I see that gets missed out in a lot of the communications is it goes targeted at everyone involved in heavy vehicle transport, full stop. And it makes it sound like you are suddenly responsible for anything and everything that goes on in the chain, regardless of how close you are to it or whether you've had actual involvement in that activity. That is not the purpose of COR. The purpose of COR is to make sure drivers of heavy vehicles are not encouraged, coerced or forced to engage in unsafe practices which pose a risk to them or the public. Now, it's interesting, someone asked me a question as to why aren't drivers specifically singled out under COR. The reality is these duties are in place to protect drivers and to make sure that the other parties, distributors, receivers of goods and the transport operators who engage drivers are held accountable for the role that they play in a driver ending up engaging in unsafe practice. And we'll talk about that in a minute. So, proactive, I've just got a question there about reasonable practicability, we'll get on to that, and also collection of material, and we'll talk about all of those things. So I may not answer some of the questions as we go because hopefully they'll get a bit answered along the way. The duty is proactive. You have to look forward. You have to look at preventing risks associated with heavy vehicle operations arising from your operation and matters over which you have control. So you need to have a look at what's going on in your business and how you can influence the safety of a heavy vehicle. Who are the duties targeted at? I've essentially collapsed it down into 4 groups. The distributors' goods, the transport operators, not drivers per se, and the receivers of goods. And the other addition as well is the decision makers within those organisations, so the officers, the senior management are the decision makers within those companies, and we will actually talk about that. I've got a slide on that in a little while. Okay, so this shared obligation, this is a term that I think is creating a lot of turmoil. What is the definition of a heavy vehicle and is it the same across all states? My understanding is yes, because it's national legislation. Whilst it was enacted in Queensland, all the other states have adopted it. And yeah, talking here, aren't drivers responsible for their vehicle? Good question. Certainly drivers have obligations. And if you look at the heavy vehicle national law, there's not just COR. There's actually a number of other chapters. The COR obligations are in Chapter 1, which sets out safety duties. Then there's Chapter 3, 4, etc., which says, you know, there are these obligations around making sure the truck is safe, managing fatigue and all of that. That's really where the duties of drivers come into. So COR is one part of heavy vehicle national law. And I get this kind of sense that people sometimes forget there's this other part of the legislation which sets down how do you have to manage or operate a truck safely. Okay, the shared obligation is to make sure you don't do anything which forces another party in the chain to engage in unsafe practices. It's not about interfering in another party's operations which you are not involved in. So the classic example is, I'm a distributor of goods. I engage an independent contractor as a transport operator to come in, pick up my goods and drive them off down the road. I don't have anything to do with the buying of the truck, the maintaining of the truck, the driver's licensing and competence with regard to operating the truck. I can have some influence over fatigue and so forth, as we know, because of my own practices. But the COR does not mean that you need to start looking at your contractors and going, okay, well, show me everything you've got going on over there, because you're not involved in them. And this is the effect of adopting the interpretation of contractor duties under Biata Poultry, which is the High Court case in 2012, and we'll talk about that in a minute. So COR is about obligations owed to drivers who are impacted by your operation. So you really need to remember it's about matters I have control over. It's about looking at your own operations. I see a lot of questionnaires getting around about asking other operators in the chain about what they're doing. Look at yourself. Look back at yourself and say, what is it that I'm doing? By saying to a transport operator, you know, give me evidence of all the maintenance you're doing, give me evidence of all the licensing you're doing, is not really very fruitful. The best thing you can do is say, what is it that I do that impacts on a heavy vehicle, operation of a heavy vehicle. The changes actually give teeth to the NHVR to prosecute parties who contribute to heavy vehicle incidents who are not directly involved in the operation of the vehicle, but, and I should have added it here, who have influence, real influence, or direct control over whether that driver operates the vehicle safely. And we'll talk about what that real influence is, because we've got to, so we go down here. So out with the old, in with the new. So the reasonable steps test is out. It is no longer the test that will be used in a court case to determine whether or not a party has met its obligation. Reasonable practicability is in. It is defined, and we'll look at what that means in a minute. So the previous case law applying to reasonable steps is actually no longer applicable. It will all be tested against the interpretation of reasonable practicability, like in cases like Biata poultry. But it might be reasonable steps. Some of the outcomes of that case law might be informative as to what is reasonably practicable. Okay, so please make sure that if you're getting advice from people, a sure sign that they're up to speed with what is happening is that they've stopped talking about reasonable steps and they've started talking about reasonable practicability. So what is reasonable practicability? So the workplace health and safety legislation in Victoria has talked about reasonable practicability since 1985 and has been implemented across all states basically now under the harmonised workplace health and safety legislation. So it's a two-step test. So what you have to do is think about what are my risks, and then first and foremost think about what can be done to manage a risk or eliminate it. So what's the best thing I can possibly do to manage this risk? And then you think about, is it reasonable to do that considering the likelihood of the risk, the severity of the outcome, knowledge of ways to control risk, suitability of the risk control method, and cost. So reasonable practicability is not what is physically possible. It is about weighing up problem solving the criteria above in the context of safety as a priority. So we know if a truck is going down the road and drops its load, so the risk is that a load falls off the truck. The likelihood may well be quite low because I'm not sure that it happens all that often given the number of transport movements around the country. But the severity is likely to be pretty bad because you're going to be on the road with other vehicle users and, if somebody gets hit by a load falling from a truck, it's likely to be pretty catastrophic. So we'd say, okay, we reckon there's a pretty high risk level there, a catastrophic risk level. So that means we need to take probably a pretty significant degree of action to prevent that from happening. And then we'd say, all right, is there knowledge about ways to control the risk? We do have knowledge about things like, someone's just said WHS law talks about so far as is reasonable, practicable, is there a difference or a connection? It's the same thing. So I'm discussing what is reasonable practicability. It is the same thing as so far as reasonable practicability. So then we think about what are the ways. So we know there are methods of load restraint. We know that, there are methods available to prevent loads from falling off trucks. Is it suitable and appropriate to use those methods? We'd say, well, yes, there's no reason why loads can't be restrained properly and the cost is reasonable, so we should do it. But I was actually talking to someone the other day about issues where, say, containers are brought into the country and we're concerned about the contents of the container. Now, the knowledge about ways to control the risk is that we could open them and inspect every container, but actually they're under quarantine and they're sealed, so it's not suitable to actually open every container. The cost and effort to do that would be absolutely prohibitive in terms of the transport industry. So we'd say, well, whilst it might be, the best possible method is to physically open every container, it's not reasonably practicable because it's just not suitable given what might be in the container and quarantine issues and all those other things, and the cost associated is simply too high. So reasonable practicability limits the effect of the obligation. So if we put, as the Act does not require, or reasonable practicability, the definition does not require employers to ensure accidents never happen. Okay? It actually accepts that accidents do happen, and we do accept a certain level of risk. What we try and do is reduce it as far as is practicable. The court must look at the facts of each case as practical people would look at them, and I like this quote, not with benefit of hindsight or the wisdom of Solomon. So it's really looking at the practicality of the situation. But we need to take the responsibility to control risk as far as is practical by taking an active, imaginative and flexible approach to dangers. So we need to look at each situation on its merits, what's happening, what's going on. So we can end up with some prescriptive guidelines or some guidelines about how we might respond to a situation, but the key is to look at each situation and adjust how it is that we're responding. Questions of safety and practicability in many cases raise issues of common sense rather than specialist knowledge, which is an interesting observation. And it also does not mean doing anything possible. Okay, so these quotes around, you know, you must do anything and everything possible to prevent a risk is simply not how the reasonable practicability test is interpreted. So there is a limitation to both the workplace health and safety and the HVNL duty, which is the same. The obligation to eliminate or reduce risk so far as is reasonably practical is qualified by the capacity to influence and control the conduct of others. This is real control and influence. I know people say, oh, but I can influence, you know, somebody way, way, way away from me just by, I don't know, being in the chain of responsibility with them. That's not true. It's about having, you know, real influence and real control, and that in your decisions there is what they call a nexus of connection between what you do and the outcome of what the other person does. So, and that capacity to influence and control another party, deciding to do that, is limited by the cost and effort of controlling and directing independent contractors in their safety arrangements. That was an observation of the High Court in the Biata case, which basically said, sure, I could be issuing my independent contractors with a whole bunch of instructions about how to go about their business. But the nature of a contract is I've got an expert in to do a particular job. Why would I be telling them how to do that job? And also the cost and effort of doing that is not, just doesn't make sense in looking at, well, why do we engage a contractor? It's not our core business, and it's not, you know, very value for us to start interfering in how they run their business. So Biata Poultry, and this is really where the High Court basically said just because a principal contractor, which is a person engaging the contractor, has a legal right to issue instructions and it is possible to take that step, it does not establish that it is a step which is reasonably practicable to provide and maintain a safe working environment. Now, interestingly, they even went as far as to say, even where the principal contractor has knowledge of the risks and knows of ways to control risk, what they're essentially saying is, you're an employer, here's a contractor, you are separate entities. You are engaging a contractor to undertake work for you, and you are entitled to rely on them to manage their own safety affairs. This is where people start to get all hot under the collar about contracting out. We are not contracting out our obligations. What we are doing is saying, I'm buying in somebody else's expertise or somebody else's, you know, the processes to actually help me meet my obligations to make sure this work is being done safely. And the court basically said to achieve that, you just need to be able to demonstrate a level of due diligence when you engage your contractors. And that's why I've been working on the one questionnaire for 7 years. So to show how we do that and to keep it as simple as possible. I looked at a questionnaire the other day that was something like 20 pages long, and I just needed a big lie down afterwards. So there's been a number of other cases that actually came before Biata as well, which said, look, once an activity has been organised and its operation is in the hands of independent contractors, liability for negligence by them, the contractor, within their area of expertise, is not borne vicariously by the principal contractor. So one of the important things is to say, where do my operations finish and where does the contractor's operation start. And in transport, I actually think it's fairly easy to do that. I mean, in some industries like construction, it can be really confusing to go who's who in the zoo and who's doing what. But in transport, if you're receiving goods, loading, unloading, all of those things, it's pretty clear what your operations are and what you've got control over. Then the transport operator comes in or the driver comes in. You can clearly see what it is that you're doing that impacts on their safety. You know, when you load your goods onto a truck, you've got control over how it's loaded, what it is, how much it weighs, its dimension, you know, how it's located on the vehicle, all of that kind of stuff. So it's about sort of everybody sticking to what, you know, they have that control over. There was a case, or a client that I actually did some work for last year where a notice was issued requiring them as a principal contractor to essentially collect all the maintenance records from their operators, get all the copies of pre-start checks, all of this kind of stuff. And essentially we appealed that notice and had it withdrawn on the basis of the principal step down in the Biata poultry case. And that directly relates to transport operations. So, no, you don't need to be running around asking your contractor for copies of their maintenance records or copies of licenses or copies of all of those things. That is what they have control of, and that's what they will be held liable for, not you as another party in the chain. So this is another one that clarifies. This was a Fortescue Metals case in WA, where Fortescue Metals engaged an independent contractor, were prosecuted for an incident arising from the contractor's work. And the court confirmed that whilst the respondents, such as Fortescue Metals, could not delegate or contract out of their duties, they could perform them by ensuring that an appropriate, experienced and qualified person was retained to deal with matters beyond their own knowledge and ability. So the question becomes, how do you ensure that you've engaged an appropriately experienced and qualified person? And this is where we've seen the rise and rise of very complicated and odious and onerous questionnaires and the requirement of the preparation and delivery of reams of paperwork appear. And it's quite simply not helpful, because generally what we find is, you know, subcontractors will go off and prepare something for the purpose of giving you your paperwork, and that is not actually used on a day-to-day in managing their safety. But we'll talk about safety management systems and whatnot a little bit later. So even if we then go on and look at the transport cases, you know, the prosecutions by the NHVR that have gone before, it does confirm that their prosecutions were really only successful where it could be proven that a party, other than the operator, transport operator or driver, had an actual role to play in the causing of the incident and played some part in directing or directly influencing the safe operation of the vehicle. So, for example, a distributor overloading a truck causing a rollover, improper packaging causing goods to fall from the truck, delaying truck drivers and your premises increasing fatigue. So it's where there has been that real involvement in what has actually happened in the incident. The interesting thing is there's a couple of cases that are referred to repeatedly, and they're actually not good examples of COR and the obligations under COR. So Coots Transport, everyone says, oh my God, that's the poster case for, you know, the effective chain of responsibility. Well, it's not really, because Coots basically got prosecuted for failing to maintain their vehicle. That is a primary obligation of an employer to ensure that they are conducting their business in a safe way. Ramondas, you know, this thing about contracting out the weighbridge to weigh their truck. Well, again, I mean, Ramondas were the ones that were loading the trucks. They created the risk. All the weighbridge was doing was weighing them and sending the information back to Ramondas. Ramondas was failing to manage a risk that they had created. I mean, if Ramondas had instructed the weighbridge to say, okay, whenever you get an overloaded truck, you need to send us an email by, you know, urgent saying this truck has been overloaded, and or if they said to the weighbridge you need to direct that truck to stop and offload, then that would extend the amount that the weighbridge was involved in, and Ramondas would have been using them to help meet their obligations. And the other one was the Colbert Transport one, where the fellow Colbert Transport and the director was prosecuted, and for failing to maintain a vehicle, and a fellow got killed. So again, their primary obligations on employers to manage risks directly arising from their business. So they're not great examples of how the chain of responsibility works or what it's there for. It's essentially there to say that the parties in the chain, either side of the driver and the vehicle, so the distributor and the receivers of goods, as well as the transport operators who may engage independent driver or use their drivers, need to be not doing things that put the drivers and the running of the vehicle at risk. Okay, let me just scroll down there. This talks about here, I'm assuming it would be reasonable to expect a principal to ensure the contractor has a system in place to meet the requirements of COR. Yes, that's right, but what does that look like? And that's where we run aground again. So going back here, so questions that you need to consider. What control does an employer retain over matters of health and safety with respect to contractors it engages? So how is it that I influence my contractors? Obviously when they come to my site, I've got management of the site. And if I'm, in the transport context, actually doing things that impact the safety of the vehicle or the safety of the driver, then I've got a level of control. The other question is it reasonably practicable for an employer to specify and enforce arrangements to be adhered to by contractors? And what I'm talking about there is going to a transport operator or a driver and saying, okay, I'm going to direct you in how you actually run your own truck. It's just not practicable, reasonably practicable in terms of productivity. And interestingly, when I spoke to the NHVR about it, they confirmed that one of the reasons these COR changes are in and it's aligned with workplace safety is to improve productivity. Okay? So consider the elements of reasonable practicability. What do I know about this contractor's operation? Is it suitable and appropriate for me to be interfering with their arrangements? And what is the cost and effort of doing that? So knowledge of the work, do we have the right knowledge? What's the cost and effort and the cost and effort of directly supervising an independent contractor? One of the things that I get a lot of feedback from contractors about is, when the person engaging me rolls up and starts telling me how to run my business, they actually make my safety worse. They make me do a whole bunch of stuff that doesn't improve safety, slows me down, makes my staff focus on process and procedure rather than day-to-day safety. So, the million-dollar question, what are we required to do to demonstrate due diligence? So, engage contractors with a good reputation. If you've heard of contractors that run a tight ship, use them. Word gets around within industry. Ask the right questions. As I said, I've spent 7 years writing one questionnaire that is about 4 pages long. Don't collect copious paperwork. Paperwork is not evidence of actual practical implementation of safety management on the ground. Unfortunately, it's become an industry in itself. And we talk about safety clutter in a little while. Clearly establish the scope of work and responsibilities of each party for safety. So if you've got a truck coming into your business, you're establishing the scope of work is that, we're going to load, we are going to make sure that the truck is loaded properly, it's not overload, it's not over dimension, it's all that kind of stuff. Or is the driver going to do that? Is the transport operator going to do that? So be clear who is doing what and who's got control. Understand what obligations you retain, as I said before, so your own site safety and managing risks from your own operations. Consider how your operations pose risks to drivers. Direct contractors to remedy safety concerns without directing how this is to be done. The temptation to step in and tell your contractor how to run their business can land you in increased liability. And there's been a couple of cases where a principal contractor has intervened in an independent contractor's work and started directing them in how to undertake their work, and an incident has resulted, and the principal contractor has subsequently been prosecuted on the basis that they took control. And one of the cases that will be quite interesting to see what happens is the multiplex case that happened earlier this year, where a crane, actually the incident didn't happen this year, but charges were laid against multiplex in respect of a crane operator as an independent contractor and the crane rolling over. So that will be a really good test of what happened and why was it deemed that the multiplex people had intervened to the extent that they were actually taking control and reliable for prosecution. So what should I ask? As I said, I've looked at a number of long and arduous questionnaires. I've looked at a number of, how we go about thinking that we're gathering information. I find it interesting that a lot of questionnaires tend to circle around what they're trying to ask. So around training, we say, do you identify the training your drivers need? Do you have a training program? Do you review your training content? Do you record drivers' attendance at training? The only thing that you actually want to know is, are your drivers competent? So think about what is the real thing you want to know about, if you're asking a transport operator or a driver or a vehicle operator about what they're doing to manage their safety. What is it you actually want to know? I don't really care about the process of how they got there. I want to know, have they got the outcome that I want? So are their drivers licensed? Are they competent? Are they fit for work? And are vehicles safe and fit for purpose? So that's what we want to ask our transport operators in a nutshell. With others, so if we're looking, so a transport operator should also, or drivers should also be going back to other parties in the chain, which is your distributors and your receivers, and saying, well, actually, are your work processes designed to support drivers to observe speed limits, comply with road rules, maintain fitness to work, load within vehicle limits, and correctly restrain? So we can be super efficient in how we, how we actually gather this information. I've just got here, a question is, let me just go down here. How do our obligations vary between a captive single-owner operator compared to a larger multi-owner? It doesn't make any difference. It really doesn't make any difference how big your organisation is, because it's the relationship that matters. It's basically saying business A needs to think about how it impacts on the safe operation of a heavy vehicle. Now, business A can be the distributor of goods or a receiver of goods. Sometimes businesses are both, but essentially think about it in the three key elements of the industry, which is distributing goods and receiving goods. And there's transport operators in the middle who are engaging, smaller operators to actually do their work for them. But it doesn't really matter about the size of your business. And I find it interesting, we get the same thing in workplace health and safety. People go, but we're a big business, we must need something really complex. And I just go, not really, because the principles remain. So, monitoring. Ask questions if there is a problem. Look at what is happening. Discuss your concerns. Use the expertise of your contractor. So if you want to monitor the activities of your contractor, and this is a really controversial thing to say, and everyone jumps up and down when I say it, in reality there is no legal obligation to monitor or supervise your contractors' operations in relation to their operations, which you have nothing to do with. But, if you do want to get out there and monitor, get out there, have a look, ask questions. Don't run around collecting reams of paper, because it's not going to tell you much. Everything just starts to, write stuff down because it becomes a bit of an ass-covering exercise. Sorry to put it so crudely. If you have a contractor who has poor safety, then refer them for assistance. Get them to get expert assistance. Sometimes we say, oh, but I'll help them myself. Well, you're better off to stay arm's length. Say to them, you need to go off and get some help to actually develop and manage your own system. Be realistic about what you require. And this is in relation to documented systems. A lot of what I see being advertised is targeted at the big end of town. And my understanding is about 80% of all transport operators or driver or owner operators are 1, 2, 3 drivers, or mum and dad or whatever. They are not capable of, and it is not relevant to them to have significant reams of documentation, and it's arguable it doesn't help improve safety anyway. Keep it simple, keep it focused. Terminate your contract. If you know someone's a poor performer, just terminate it. If you've gone back to them and said, look, can we work this out? Take actual action. Conduct random physical reviews if you have the knowledge to do so. So again, we shouldn't be feeling like we have to become an expert in every type of operation across the chain, because that is not what is required. So the primary aim of COR is that every party in the chain gets their own backyard in order. It's not driving everybody else looking over the fence going, well, I wonder what they're doing over there, even though it's really got nothing to do with me. So have a good hard look at yourself and your operations. Remove those part of your operations which result in drivers, either deliberate or systemic, engaging in unsafe acts. So are you actually directing a driver to say, I need this parcel to go between Melbourne and Sydney in 8 hours, which you can only do by speeding? Or are your systems such that you say, well, we've got a slot that you need to make for a wait time, but you've missed your slot, so you've got to go over there and wait for 5 hours. So your systems are forcing drivers to end up being fatigued. And I was thinking about it last night, actually. I was thinking, well, maybe what we need to do is have, and things like weight rooms for drivers. We have the little white painted square and a chair in the middle, and the driver can sit in that square with his cup of coffee on his plastic chair. Well, maybe in these big DCs or big way, we need to have a bunk and a shower and a restroom and the whole bit. But anyway, that's a whole other story. So COR duties does not extend liability for operations of others in the chain, e.g. a freight forwarder is not responsible for vehicle maintenance or licensing of a contracted transport operator. It's really about saying each and every party needs to sort out their own stuff, and if that happens, then we would have a complete and unbroken chain safely operating across the transport industry. But while everybody's looking at everybody else, in relation to a whole bunch of stuff that's not really relevant to them, we are just wasting time. So I've got here, so you're saying that the responsibility of a load being delivered to a building site is the responsibility of the driver to get from A to B. Yes, it is, but there is also, so if you've got a building site or you've got a distribution centre that's sending concrete out and the truck rolls up to get loaded, it is the responsibility of the distribution centre or whatever to make sure that the load is as it said it is. It weighs what it said it should weigh. If they're saying we're going to load it for you, use our forklifts and stuff, it's got to be loaded properly on the vehicle. It's got to be restrained properly. They need to not make the driver wait so long that they end up driving out of the distribution centre exhausted. But essentially, once they've done that, if the driver is on the road and they speed or the truck isn't maintained, then that is the issue of the transport operator or the driver. Okay? It's got to hear in the situations where drivers receive speeding fines, what are the circumstances where employers will also be fined? I don't think that's actually even an option at the moment, but it probably wouldn't be a bad one. Because you go, well, if you're actually, pressuring someone through commercial means or whatever to speed, it might be nice to be able to get a fine in there to increase our level of influence. All right, so I'm just going to go over quickly. Basically, I've sort of touched on this. So it costs distribution, transport, and the receiving of goods. Now, that little chain can repeat over and over and over across. So, but essentially, they are, from what I can see, the three elements of the transport industry. And then we need to think about what heavy vehicle risk outside of your own operational risk, what goes on in your own workplace. Do you have control or influence over? So if we look at it, we go distributors. They engage the transport operators, they consign goods, they pack and load, they schedule delivery. So the heavy vehicle safety matters over which they may have control or influence is they can overload trucks, they can load dangerous goods or goods that are not labelled properly or not, what they said they would be, scheduling delivery times to force speeding or increase fatigue, and increasing wait times for drivers, which is increasing fatigue. So what the COR does, what the legislation now says is, okay, if you're a distribution centre and you have made a driver wait in your distribution for an exorbitant amount of time, they go over their safe driving hours and have an accident on the road, you may well be and are likely to be included in any prosecution or any enforcement activity that goes on. If we look at transport operators, so they load, they transport, driving A to B, and they deliver the goods. So obviously the matters that they have control over is the vehicle safety, the driver fitness, overall driver fitness, driver competence, load restraint, licensing, mass and dimension. So, you know, they have the ones that have to maintain the vehicle, get a new vehicle when they need to, make sure their drivers understand about driving hours, fatigue, drug and alcohol use, all of that sort of stuff. And they're the ones that need to make sure they're competent and licensed. Okay, so that obligation sits with them. Doesn't sit back with the distribution or it doesn't sit with your receiver. So essentially with receivers, they're involved in unloading goods. So probably the main thing that they have an influence over is wait time. So if you get a driver in and you make them sit and wait for hours and hours on end, then, and there's a problem out on the road when they leave, then you have a problem as well. Okay? So, safety management systems versus systematic management of safety. Now, I know that there is a big promotion around implementing safety management systems. Workplace health and safety has worked out over quite an extended period of time that safety management systems are as much a problem as a solution. They are generally complex, long, and they result in a term called safety clutter. And I've taken a quote here from Andrew Ray and a group who have you know, really highlighted this issue around safety management systems and the impact that they can have on diverting us, actually. Someone's just said, if our contracted truck drivers are forced to wait for an extended period of time, but we don't put a time limit on how long it takes to get to the destination, surely their fatigue management is their responsibility. It's an interesting one, actually, because just had a little feedback saying it's slightly muffled. I'm not sure what's going on there, but anyway. So, okay, so we've got, in that situation, you would have the party creating the wait time. So there's either the distribution or the receiver of the goods is making them sit and wait. There are certainly obligations, as I said, in other parts of the heavy vehicle national law that say the driver needs to be managing their own fatigue. And so what I would probably say there is the obligation rests with the party creating the risk, and not under COR per se, but under the other parts of the legislation, the driver has an obligation to say, I've gone over my hours, I can't actually take this load now. Now, your job as the transport operator who's contracted that operator, because you haven't specified a time that it needs to be delivered, is to support them to say, we'll be back to pick it up later when we're back under our work hours, or we're sending another driver to pick it up, and to actually facilitate that relationship with the other parties so drivers feel that they don't have to succumb to the coercion or the pressure to just wait and work over their required hours. The vexatious question, what if a freight forwarder sees a subcontracted driver that is fatigued or who is impaired by drugs, alcohol and does nothing? Look, the reality is obviously we don't want that to happen. You know, we really want people to be able to, we want people to intervene, we want people to take action and so forth. But it is a vexed question, and I actually put a post on LinkedIn a while ago about, and it comes up in general workplace health and safety, about do I have to intervene when I see someone doing something unsafe? As a general rule, under common law, there is no positive duty to save someone from themselves, but the law obviously modifies some of these duties, and essentially it's a problematic question. And I would say it's always good business. It's always good business to take action, and nobody wants to be involved in an incident, not because of the legal ramifications, I have to say, being prosecuted is the least of your worries in relation to safety. The sheer resources alone in the regulators, both in workplace health and safety and the NHVR, are simply not enough to prosecute, every time something goes wrong. So the reality is the drivers around, pardon the pun, around safety in transport industry, our reputation, good business practice, saving money, the commercial reality. So, that's why we want to be actually doing things, not worried about, am I ever going to get prosecuted? We've only got a little bit of time left, sorry. So most safety management systems are safety clutter. Most of the time, like my little guy there, we're looking at a bit of paper instead of actually looking at what's going on around us and managing safety in a moment by moment. We want to establish safety cultures where we're saying to our workers, and that includes our contractors and our own workers, look up, look around, see what's going on for you now, be in the moment. Look up from our checklist to see hazards, talk to each other, problem solve, take real practical action. Keep minimal purposeful records for information sharing. Forget collecting copious amounts of evidence for the prosecution that's probably never going to happen. Whenever I work with a client around safety management systems, I always say, we're going to look at what we need to be doing to manage our risk. Then we're going to decide, do I need a document to actually record this or not? I have seen safe work methods or safe operating procedures for vacuums, and quite frankly, all it does is offend people, adds nothing to safety, and we need to be really, really tight about what it is that we are actually recording. The other thing is use other technology, use videos, use recordings, use phones. People have phones, use those kind of things to deliver information in a way that is real time, that is far more interactive and so forth. But also our workforces, we need to trust them. We need to give them authority to actually take action. And it's interesting. I thought I added a slide actually. I had a slide in there which doesn't seem to have come in about officers. Now, grab a pen, because the slide doesn't seem to have been added in, but grab a pen. There's only 4 things that an officer needs to do to ensure that they can demonstrate due diligence. They need to ensure that they obtain and share knowledge about the operations of their business. So they need to get expert advice, and they need to understand what the risks are in their business. They need to gather that information from their workers, and they need to share that knowledge with their workers and other contractors and so forth, or drivers or whoever it is, about the risks associated with their business. And they share that by providing the resources to do that. So they pay for training, they pay for the good equipment, they pay for, risk management strategies. So officers are the executives within the business. So they need to gain and share knowledge. They need to provide the resources to actually manage safety, push that down through the organisation, make sure that people are well funded with time and money to actually take action. They need to authorise and permit the people in their business to make safety a priority. Yes, we will make sure the extra slide is added when it's sent out, so that's fine. Authorise people and say, I give you the authority to take action to manage safety on a day-to-day basis. I am not with you all the time. I want you to know that your safety is important, and I want you to make it a priority. And then the last and fourth thing is holding themselves and others accountable for safety outcomes. And that's where you're monitoring around, am I getting reports back on what's actually happening on the ground? So if you do those 4 things, knowledge, resources, authority and accountability, as an officer, you will have covered off your obligations under due diligence, and be in a good position where if there were to be an incident, you can say, well, I have created the environment in which safety can be successful. Because that's really what officers and executives do. They are enablers across the business in every sense. So basically that's, what officers need to do. But look, we're at 3:27. It's a lot to pack into an hour. I've tried to give you a summary of the information. obviously, you know, and I've tried to answer questions as they come along, but obviously with here's Frank J. I can't agree with forgetting evidence. I've worked as an expert witness the last 10 years, and the lack of a sound evidence either saved or convicted of saying that is a bit of a long shot to say the least. Look, I've worked as an expert witness as well, and I've drafted reports as an expert witness, but what I find is that, and certainly there are things that do get relied on, but the reality is we get so caught up with preparing documentation that it becomes a barrier to actually taking action, which will prevent the need for an expert witness in the first place. And saying that a prosecution will never happen, I'm not saying it will never happen, but it's far more remote than you think. I remember sitting in a session with a WorkSafe executive director, and he turned around to a whole bunch of very senior heads of workplace health and safety and said, you've got more chance of winning tax than you have of getting prosecuted. It's not the best driver and motivator to manage safety, because you need to say to yourself, well, actually, I'm going to suffer commercial, reputation, all that other stuff first if my operations are not managed soundly in relation to safety. You won't be an employer of choice. You'll have dissatisfied workers. You will end up, you know, having a business that is not as successful as it could be. Quick question here. Is an officer and PCBU considered the same thing? No, they're not. So a PCBU is the entity that is conducting the business for undertaking. So that is either, that can be a sole trader, a partnership, a company, an ABN, well, yeah. So basically that's the entity running the business. An officer is an executive person involved in the business. So a director, a managing director, a board member, a CEO, a general manager. So that no, they are not the same thing. Someone has just said your thoughts on the draft master industry code of practice, please. I've run out of time, but I probably will put a post up about that on LinkedIn. So it's 3:29. I'm going to throw back to Shona. Please come back to me with questions. I really love people to come back and go, I think that's rubbish. So I can say, well, that's why, you know, and I'm really happy for people to disagree with me. And also put cases up and say, well, what about this case? What does this show us? Because invariably I go away, I read the case, and then it's a good opportunity to tease out what it is these things are telling us. All right, so Shona, can you close this out for me? And thank you, everybody, and please feel free to email me.
Thank you to Sue for your presentation, and thank you to everyone for attending the webinar. Please stay logged in to take our online survey, which will be redirected to you shortly. We thank you in advance for your feedback and wish you a pleasant afternoon.